Okay, let's dive right into this explainer. Today, we're unpacking a really comprehensive roadmap for navigating the end of a marriage, respectfully and legally, in India. We're going to walk through a step-by-step guide drawn directly from family law experts to help you understand a process that, frankly, prioritizes clarity over conflict. So, ending a marriage is incredibly hard, right? But does it actually have to be a battle? While divorce carries a massive emotional weight, today we're exploring a cooperative, dignified route that completely sidesteps those bitter courtroom fights. We often picture divorce as this dramatic, adversarial war that drags on for years and years. But it really doesn't have to be. If both parties are on the same page about parting ways, Indian law actually provides a highly structured, much more peaceful off-ramp. Right, here's our roadmap for today's explainer. 1. Understanding mutual consent. 2. Eligibility and laws. 3. The 7-step process. 4. Documents and jurisdiction. 5. Waivers and timelines. And finally, 6. Life after the decree.
Section 1. Understanding mutual consent. Why choose the cooperative route?
The absolute biggest takeaway here is that you do not need to prove cruelty, desertion, or adultery to legally end your marriage in India. That is a massive distinction. Under mutual consent, there's zero blaming. Neither party has to stand up in court and point fingers. You simply agree that the marriage is broken beyond repair, and you jointly approach the family court. It's really that straightforward. Now, the sheer contrast in time, money, and mental health when you choose cooperation over litigation is absolutely staggering. Seriously, a contested divorce can literally trap you in the court system for years, completely draining your finances and your emotional energy. Mutual consent, on the other hand, is designed to be highly efficient. We're talking about wrapping the whole thing up in just 6 months to a year. It's universally the preferred choice because it protects your shared finances, your mental well-being, and, most importantly, it shields any kids involved from prolonged conflict.
Section 2. Eligibility and legal frameworks. Basically, packing your bags for the journey.
So here's an absolutely crucial point. Under most personal laws in India, couples must have lived separately for at least 1 full year before filing their joint petition. This is entirely non-negotiable. The courts want to see that you've actually experienced life apart and that this isn't just some temporary heat-of-the-moment disagreement.
Judges are going to carefully verify a few exact conditions. If there's even a hint of pressure or unresolved conflict, your petition is going to face major delays. You absolutely must have your big life issues completely resolved before you file. We're talking about who gets what, how alimony is structured, and the custody arrangements. If you show up to court still arguing about the house or the kids, well, the judge simply cannot grant a mutual consent divorce. Knowing exactly which legal lane you belong in based on your background is key because it dictates the procedural rules for your specific case. For instance, if you had a civil or interfaith marriage, you'll be looking at Section 28 of the Special Marriage Act. If you're Hindu, Sikh, Jain, or Buddhist, it's Section 13B of the Hindu Marriage Act. Identifying this accurately is your very first practical step because it literally dictates the whole shebang. Moving on to Section 3, the 7-step divorce process, navigating the route. So these first 3 steps, they happen completely off camera. Usually it's your desk with your lawyer, forming a rock-solid foundation that prevents disputes later. Step 1 is arguably the most important, drafting the settlement agreement. It needs to be incredibly detailed to prevent loopholes that could spark arguments years down the line. Then, in Step 2, you prepare the formal joint petition declaring the marriage is irrecoverably broken. And finally, Step 3, you file it together in court. This formalizes everything and gets you your case number. Once you actually step into the courtroom phase, a chronological timeline takes over, with the judge recording your consent at 2 distinct milestones. Step 4 is the first motion hearing, where the judge verifies your consent in person. Then comes Step 5, the statutory 6-month cooling-off period. Lawmakers put this in place to give couples one last chance to, reconcile. If you don't reconcile, you move to Step 6, the second motion hearing, where you reaffirm your decision. And finally, Step 7, the judge issues the final decree of divorce, permanently dissolving the marriage. Section 4, Documents and Choosing Jurisdiction, the logistical essentials. Having your paperwork flawlessly organized and verified by your lawyer is, for sure, the absolute best way to avoid getting your petition rejected on technicality. You really cannot cut corners here. You need rock-solid proof of that 1-year separation, like separate rental agreements or distinct bank statements, and, of course, full financial disclosure is critical. If courts find out someone was hiding assets later on, it can completely invalidate the entire settlement agreement. Where do you actually file?
Well, filing your case in the wrong city or district court is a super common mistake that wastes valuable time, so confirm your jurisdiction early. You can't just pick the courthouse that's most convenient for your commute. The law is very specific about the 3 locations: where the marriage was solemnized, where you last resided together, or in some cases, where the wife currently resides. Choosing the wrong one means your case gets rejected or transferred, stalling everything before it even begins.
Section 5. Waivers, Costs, and Timelines. Finding shortcuts.
Now, this ruling is honestly a total game changer. The highest court in the country explicitly recognizes that sometimes forcing couples to wait simply serves no meaningful purpose. The Supreme Court has ruled that this 6-month cooling off period is a guideline, not an absolute barrier in every single case. If you meet certain conditions, your lawyer can file for a waiver, potentially shrinking your timeline from 6 months down to just 1 or 2 months. If you've already been living apart for a substantial amount of time, you've tried mediation and it failed, and absolutely everything is settled, the court may agree to waive the waiting period entirely. It is highly recommended to ask your lawyer to file for this waiver right at the first motion hearing if you fit the bill. As for costs, while you definitely should budget for modest court fees and a really skilled family lawyer, this collaborative approach is inherently the most cost-effective option out there. The court fees themselves are usually just a few thousand rupees. The variable is the legal representation. But even with premium legal counsel to help draft a bulletproof settlement, it is vastly cheaper than paying a lawyer to fight out a contested divorce over 3, 4, or even 5 years.
Section 6. Life after the decree. Arriving at the destination. So, after the decree, completing a few simple updates ensures your legal records are clean and prevents huge headaches if you choose to relocate or remarry down the road. Seriously, don't skip this step. Taking your certified degree and promptly updating your Aadhaar, PAN card, and banking details ensures that your new independent life starts on a perfectly clean, legally accurate slate. A mutual consent divorce empowers you to transition out of a marriage with respect and certainty. It proves that even the most difficult life changes can be managed cooperatively and systematically. So before you consult a legal professional, ask yourself, if a marriage must end, shouldn't the focus be on building a peaceful foundation for whatever comes next, rather than winning a bitter war? Thank you for joining me for this explainer.